Here's my question. Yesterday, I read this article. This is from April 5th, and today is the 10th. So this was just from last week. And it got no coverage in the mainstream media, none, which really surprised me, that the Indiana Court of Appeals, now keep in mind, let me back up a little bit. When the Dobbs decision came down, saying that, you know, states can outlaw abortion if they want, the first state to take advantage of it was Indiana. And they passed basically a complete ban on abortion, a 6-week ban. And the ACLU of Indiana sued, and they sued on behalf of 5 anonymous Jewish, Muslim, and spiritual, they call them plaintiffs, and a group called Hoosier Jews for Choice. The spiritual group actually called themselves pagans. So no Christians, no self-professed Christians in this bunch, but Jews, Muslims, pagans, and this group, Jews for Choice. And their argument was that their religion not only allows for abortion, but in some cases mandates abortion. And they could demonstrate this, you know, through sacred text and customs and practices and all kinds of things. So under the Religious Freedom Restoration Act, which was signed into law by Mike Pence, when, in fact, when he signed it, this is when he was governor, he said, the freedom of religion for every Hoosier is enshrined in the Constitution of the United States and the Indiana Constitution, blah, 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 blah. For generations, these protections have served as a bulwark for liberty. So what these people claimed was because their religion allows for abortion, therefore, they don't have to comply with the abortion law in Indiana. You know, just like the Masterpiece Cake guy said, I don't want to bake a cake for a gay couple. And so the anti-discrimination laws don't apply to me because I'm a Christian. Or the woman from Colorado who had the web design company that had literally never been asked to design a website for a gay marriage, a gay wedding, but thought that might happen and took it all the way to the Supreme Court, which should not have happened because there was no injury. But in any case, it's basically the same argument. It's the Hobby Lobby argument. We shouldn't have to pay the insurance companies for health care that includes birth control and abortion. And the insurance companies won't provide us with a policy that excludes birth control and abortion because of federal law. And the Supreme Court said, well, that federal law is wrong. And now Hobby Lobby can buy health insurance for its people that doesn't provide them with abortion or contraception care. That one was particularly weird because it was a corporation suing, saying that its religious liberties were being violated. A corporation. So they quoted, in fact, they actually quoted the Burwell v. Hobby Lobby case. This is from one of the 3 justices on the Indiana Court of Appeals, saying, if a corporation can engage in a religious exercise by refusing to provide abortifacients, contraceptives that essentially abort a pregnancy after fertilization, it stands to reason that a pregnant person can engage in a religious exercise by pursuing an abortion. Now, here's more from the decision by the Indiana Appeals Court. The state does not explain why a victim of rape or incest is entitled to an abortion, but women whose sincere religious beliefs direct an abortion are not. Now, these were all Republicans, by the way. Three Republican appointees. Again, from the ruling, both judges Melissa S. May and L. Mark Bailey concurred with Judge Weissman's opinion. This is from Bailey, the one man in the group. It was 2 women and a man. He writes, indeed, where theologians cannot agree, legislators are ill-equipped to define when life begins. And that's really the argument here, right? It is a religious argument. He goes on to say, in a more perfect world, each pregnant woman, in evaluating her options, would have no burden beyond examining her individual conscience, counseling with her spiritual advisor, and consulting with her medical provider. But a perfect world this is not, and resulting pregnancy is not always a simple free will contract or agreement. He goes on to say, legislators, and he's pointing out here that only 1/4 of the legislators in Indiana are women. 3/4 are men. And speaking to that, he says, and I quote, legislators, an overwhelming majority of whom have not experienced childbirth, nevertheless dictate that virtually all pregnancies in this state must proceed to birth, notwithstanding the onerous burden upon women and girls. They have done so not based on science or viability, but upon a blanket assertion that they are the protectors of, quote, life from the moment of conception. So this happened, right? Now it's this appeals court decision is on hold pending an appeal to the Supreme Court of Indiana. And I'm guessing the Supreme Court of Indiana will probably strike it down, but who knows? But it raises a question for me. Given that this decision has happened, that the Indiana Appeals Court has established at least a minor precedent, are there other things that people could use religion? There's either 16 or 21 states, I forget which, that have their own Religious Freedom Restoration Act, RFRAs, in law. And there's the federal RFRA law that was passed, I think, in 1994. I'd have to go back and look. But here's my question. I consider myself a Christian, for example. I don't go to church, but I try to follow the teachings of Jesus. And he was pretty explicit in Matthew 25. The only way to get into heaven, and in other words, the only way to really be a Christian is to feed the hungry, heal the sick, house the homeless, and have compassion for those in prison. I mean, you can read it right there in the Bible. And, and he's very clear. He says, in the final days, those who didn't do this, they're going to hell, the goats, and those who did, they're going with me, the sheep. So, is there some way that I could, or any of us could, who believe religiously that the appropriate thing is to be providing food stamps to poor families, is to be feeding children in public schools, is to be providing housing to the homeless, is to be having a national health care system, Medicare for all, so that nobody is denied healing that Jesus mandated? Is there a way that we can use these things for a positive benefit rather than just preventing a negative outcome? Now, so far, all of the RFRA rulings have been people getting exceptions to law. Right? In Indiana, these women got an exception to the anti-abortion law. In the Masterpiece Cake piece, the guy got an exception to the anti-discrimination law. In the case of the web designer, got an exception to the anti-discrimination laws, and on and on and on. I mean, they're all, let me out of the law that I don't like, essentially, because of my religion. So my question, and what I'm really struggling with, I wrote a whole piece yesterday afternoon that was going to be my article for today, and then I hit this barrier, which is this question that I'm presenting to you. Is there a way to say my religion mandates this, therefore government must do it? As opposed to my religion mandates this, therefore government can't prevent me from doing it. Do you understand what I'm saying? This is, up until now, all the RFRA things have been personal actions that people want to engage in that they're prohibited by law from doing. I'm trying to figure out how to use these same religious freedom acts to promote a positive good as opposed to avoiding a negative. And I haven't been able to come up with it. And I'm really struggling with this. And if you have, if any of you out there who are, smart about the law, have any ideas or suggestions, we can brainstorm them together right here on this program. So, I look forward to hearing from you.